Good evening, good night, good morning, good afternoon. Not legal advice. Like, subscribe, share. Please comment. Please do something with this. I wasn't planning on doing a video, but I received a note or suggestion from Tiny JR, and as a result, I decided to do a video tonight on Sorrento Therapeutics because there was something that came up today that might apply to companies that are naked shorted, and in particular, maybe MMTLP in some fashion. So I thought I'd just throw it out there, and maybe little tiny JR and I, at some future point in time, will do a live stream and talk about this as one of the elements. But before I started, I wanted to start off with one of my fine jokes. She had a photographic menu, but never developed it. Anyway, getting to Sorrento Therapeutics. So that was the company that was in bankruptcy, filed Chapter 11, was naked shorted. There was an adversarial complaint and actually litigation that followed between Skylex and Sorrento Therapeutics and brokers, and that action is ongoing. And while this was ongoing, the debtors and the equity committee, the parties that had an interest in the company, not the brokers, went into court and got a temporary restraining order, basically stopping the brokers and whoever from continuing the naked short, and also directing that they provide profit information. They contested that. There was a couple of extensions. There was a recent extension where the temporary restraining order with regard to the brokers was continued until a future date, but without specifying a date. And then today there was a motion. So there's a motion that was filed today by the debtor, which is Sorrento Therapeutics, the equity committee, the people that have an interest in Sorrento Therapeutics, and Skylex, which is a subsidiary of Sorrento Therapeutics, own the cancer drug business. And in effect, what happened was the motion was filed jointly, and it sought to settle out with the parties that had naked shorted. So the underlying claims that were asserted in the adversarial proceeding, the bankruptcy, related to naked shorting. And so the creditors committee and the debtor, the company itself, are offering the parties that did the naked shorting of the dividend. And so in essence, what happened was Sorrento Therapeutics issued a dividend of Skylex to a bunch of shareholders. I think it was 76 million shareholders. And it's that which was, amongst other things, that was naked shorted. And the motion seeks to give an out to those naked shorters of that dividend by having them either go out in the public market and buy the stock and cover, or privately go to Sorrento Therapeutics and buy and cover. And those seem to be the only options that are provided. In return, they'll get a release. Those particular shorters, they're not the brokers, but those shorters are not specifically identified in any of the pleadings. They're actually kept confidential, but they are identified as being separate from the brokers. And again, their interest would be, if they go out and cover, they will get a release. They'll have no liability. The same does not necessarily extend to the brokers. So this was just filed. I presume there was some meeting between some of these naked shorters of the Skylex dividend and either the debtor and debtors council or the creditors committee, and that's why probably the motion was filed. So it'll be interesting to see what happens here. Will the court grant the motion? Will they let the shorts try to purchase shares to cover, or purchase it directly from the corporation? And what's key is the pricing will be determined by an agent of the corporation and a member of the creditors committee and the debtor itself, but not the broker and not the bad guys. In this case, the bad guys being the naked shorters. So the price will have to be fairly set. It'd be interesting. That'll be interesting in terms of what the price will end up. It's a 30-page order. I didn't get a chance to thoroughly review it, but again, it refers to open market purchases by the short sellers to cover, or private purchases, describes the prices, and I think it tries to make the end of this stock purchase by restricting the stock and trying to make sure it doesn't go on beyond that. I'm going to try to get a hold of plaintiff's counsel, the counsel who drafted the motion, and see if I can get any further information. Although, since it's proceeding and since they represent their client, they may not be apt to do it. But again, to summarize, in bankruptcy, the company that's in bankruptcy, along with the creditors committee, is working out a settlement with the parties that shorted the dividend of the stock. If they buy and cover all their shares at a price determined by the corporation, an agent, and in essence the court, then they will get a release of any liability. And that's the general terms. So it'll be interesting how that plays out. It'll be interesting to see what happens with the brokers, because the brokers are not included in the settlement, and I don't know if additional information will come out about this. Anyway, I saw this tonight. It's in Texas, by the way, and the order came out tonight, July 12th, 2023. I'll have a chance. I'm going to look at it again overnight, and after I have a chance to look at it, if I have anything additional to add, I will. But I just wanted to get this out tonight because obviously if you can construct a deal whereby the short sellers are forced to cover and they work out an arrangement directly with the company, that would be a solution. Now, obviously, Sorrento was in bankruptcy, but it was a friendly bankruptcy. In other words, it's a Chapter 11. They're not going out of business. They're reorganizing. There's, different types of bankruptcies, basically two forms. One is you're going out of business, like a Chapter 7, and you're dissolving and you're trying to raise as much money and pay off as much debt. Chapter 11 or 13, but 11 in this case, is a reorganization. So they could reorganize, perhaps settle out all these claims, and then be revived and come out of Chapter 11 to operate without being in bankruptcy. So it won't impact their business. Again, I don't know how that would apply to any other company, MMTLP, NextBridge, whatever. Hadn't really thought it beyond that, other than I thought this was an interesting way to resolve the issue of open, naked short shares by an agreement between the party that was aggrieved and the party that was interested, including the shorters but excluding the brokers and leaving them at risk. Anyway, that's what I saw. It was interesting to me. Be well. Again, I'll take a greater look at it, discuss it with little JR, tiny JR, maybe big JR too. And we'll be back to you after we have a chance to kind of examine it in more detail. But I want to get that out to you because I thought it was interesting. And talk to you later. Be well.